Representative Dumpy.
Thank you, Mr. Chair. I have four really quick yes or no kind of questions, if I may.
Well, we don't know whether yes or no. We're part of the commission.
Does this bill hinder you from doing your job?
Yes.
Does this prevent input from Maine citizens, meaningful input from Maine citizens?
It would change it, because the only way to receive that input might be then to have adjudicatory proceedings for all of these types of applications. I can't answer yes or no on that one. I apologize. That's a maybe.
Does this bill prevent wind development? I mean, does it? If we pass this, does it mandate a moratorium while you regroup?
It does not require a moratorium until I regroup. The question is how I then actually accept an application as complete if I'm not able to ask for the information that's necessary in order to determine whether an application is complete.
And I'd like to thank you for the way you conducted the meeting in Bingham. I know there were a lot of emotions on both sides, and I think you and your team did an outstanding job. So thank you very much.
Thank you.
Any other questions for the Commissioner? Representative Russell.
Thank you, Mr. Chair. Thank you, Commissioner, for being here. I really appreciate your testimony, and it's helpful to have some context for the rationale behind the decisions that you made. I really sincerely appreciate that. The one thing that continues to stick out in my mind, though, is that in this application, or you call it submission requirements, there's a requirement in there that is, as was pointed out by Mr. Riley a few minutes ago, pretty consistent with the minority report that was voted down in the legislature of LD 385. Could you explain to me how wording from a bill that did not move forward, that was explicitly voted not to move forward, ended up as part of the submission requirements for an application under the very statute that particular report would have otherwise been under?
Certainly. Since the enactment of the Expedited Wind Energy Act, there has been a requirement for scenic and visual assessment for these projects, and that is the work that the department, when I mentioned the department's been working on those all the different projects that we have had since 2008, those are requirements there, and so those particular portions of the application form or the submission requirements are part of and parcel of what they had been needing in order to work through the visual and scenic impact analyses and how the department was handling those. So it wasn't a case that it was a language that was in or not in a minority bill. It was really based on the experience of the department and how we've been going through that and handling those. And I think it's been 10 projects. No one asked, but I think it's been 10 projects before the department since 2008.
Well, I hope you can understand how it would be frustrating for lawmakers to believe they were doing their job and to come to a decision and have the agency essentially override that decision through, not even through rulemaking, but through language in an application. I've come to realize that in this place that we shouldn't question people's motives, but I do think that sometimes we need to question people's judgment. And when the minority report, or when very specific language has been conscientiously and intentionally voted out, or voted not to be included into the statute, that agency directors and commissioners should certainly take that into account. Do I expect you to, parse through every single minority report out there? Absolutely not. But as it relates, and it's just unrealistic, and probably a little mean. But I would argue that this was not a small bill, and this was not a small minority report. It certainly should have bubbled up to the top of the water. And so I would hope that in the future, when you're looking at making determinations like that, that you would recognize that if something had been voted out to not move forward, that should be part of the consideration. Because, frankly, at this point, I wonder why I'm sitting here. Because if I took the time to not vote on this, or to vote on a different version of the language, and your office was able to just circumvent that by an application without any real public oversight, that causes me some serious concern. And so I just want to express that on the record in as respectful of a way possible. And I really sincerely appreciate you taking the time to provide some context for how the office works so that we can sort of see how the pieces of the puzzle fit together.
Thank you. I appreciate that. And again, I'd like to underscore that it was more the department's experience with the own permitting process, as well as the original Wind Energy Act itself, which clearly said go forth, do submission requirements based on scenic and visual impact assessment, and you don't need to do rulemaking. So it was in those contexts that we said we need to update our application form, if you will, the submission requirements, to reflect a number of the items that had happened over the years. So I do appreciate your concerns as well, Representative.
Other questions, Representative Tipping Spitz.
Thank you, Mr. Chair. Thank you for coming, Commissioner Aho. In your testimony, you said that when you did come to a ruling, you took into account the expert on visual impact, and you decided to go a different direction from what they recommended, and you laid out clearly why you went that different direction. Is that in your testimony?
It's not in my testimony. The Division Director, Mark Bergeron, will go into greater detail, but you could see, if you go onto our website, you will see where the actual decisions on the wind power projects are listed. And if you went into any of those, you would see where this is what we receive for information from a third-party expert, and those are on noise, and those are on scenic and visual impact, or the two that we usually seek some third-party guidance on. And it will also say why or why not we accepted it or tweaked it. It's somewhat similar to how you do findings of fact if you're at a planning board. You get a lot of information, but at the end of it, you still have to do written findings of fact. And so that's what we do. We're already doing that particular work already. So that part of the amendment seems... I wasn't quite sure why, since we already do that as part of our process.
Just a quick follow-up.
Yeah.
Given that that's already best practices for you, do you think it's any harm to require, you won't always be the commissioner, I assume, into the next 20 years, or maybe you will, I don't know. But to ensure that in the future that is being done, and in the name of transparency, don't you think it's good to change the rules to make sure that that's clearly stated?
It depends on how you change those rules and whether or not and how you use that information, because I believe the amendment says we have to use that regardless. I think that you want to still vest in your agencies the ability to go through and weigh all of the information they have and not say, this is the only piece of information that we're going to look at. So I think it's how you do that, and I think because it's already taken account in a number of our processes, whether they're through rules now already and our licensing processes, I'm not sure that you actually need it. And rather than pass a law to provide, oh geez, I'm not sure I should say it, but belts and suspenders, sometimes they get a little confusing. So I would not.
Thank you.
I shouldn't have said that. I have neither a belt or suspenders on, so that's...
No,
I didn't understand.
we have to have a little more fashion details here.
Thank you very much.
Are there any other questions? Representative Beavers has a
I'm
question.
sorry.
Thank you, Mr. Chair. You mentioned that based on how you're interpreting the amendment, that the only way the public would be to participate would be in a adjudicatory, I can't even get the word out, but you know what I mean, process, as opposed to the meetings you have.
Until such time as I went through a rulemaking to simply, once again, I guess, a rulemaking, or at least through the Administrative Procedure Act process, to seek public comment on a policy that's been in place since 2011.
Well, the question I have, if there's a period of time that's the only way the public can participate, that really puts, to me, a burden on citizens who might not be able to afford attorneys to represent them.
I would agree.
So I would be concerned about that if that's what results. And so how long a period are we talking about that it would take to get beyond that?
It depends. If you are actually seeking us to go through rulemaking, you have a number of questions. The first is it routine technical rulemaking or is it major substantive? If it's routine technical, then that's something that we're allowed to do at DEP, at the agency, without coming back for legislative review and final approval. Then that can be done in probably 9 months. If you are seeking major substantive rulemaking, then depending on when and how you time that, it can be 1.5 to 2 years.